Yeah, I think we had 9 or 10 signups. We're a couple minutes early. I lost you, Jennifer. Hey, Jen, I can't hear you.
Okay.
There you are. No, you're cutting in and out.
Am I cooking in and out, or can you hear me now?
Now I can hear you.
Okay, good. Okay.
Okay.
So you want me to start now? We should wait.
No, let's wait. It's 6:28.
Yeah. Oh, yeah.
So,
Let's wait 5 minutes.
wait 5 minutes and see who shows up.
Okay.
Okay. We're just going to wait a few minutes and see if we get other attendees. Looks like Lisa's here, Kelly's here, Shalisa's here. Okay. Yeah, as we're waiting, if anybody has any questions, type them into the Q&A or the chat box. And for the 3 of you who are here, if you have questions as you're going through, like Jenny said, just type them in and we'll make sure we get them all answered before we leave. Well, it's 6:30. Give it a couple of minutes and see if anybody else is going to join us. Then we'll get started, and we can always circle back if there's any other questions as we get going. All right, well, Jennifer,
Okay.
if we'd like to get started. This is, I'm Brad Jones. I'm not Shannon Jones. Shannon couldn't be here tonight. So Jennifer Sawday is an attorney. She very familiar with trust and estate planning. This is Trust and Estate Planning 101. So any questions you have, put them in the chat box, put them in the Q&A, and we'll make sure you get your questions answered. It is being recorded. So if you want to go back and review anything, you can do that. And then I'm sure Jennifer will have lots of ways to get a hold of her at the end of our webinar. So Jennifer, without further ado, take it away.
Okay, let's go. So, good evening. My name's Jennifer Sawday. I'm a partner here at the law firm TLD Law. We're over by the Long Beach Airport. So we're on Spring and Lakewood, and we're over in Kilroy. So what I want to do is I want to share my screen and put on what I consider the basics of estate planning. And if you want the charts, I will email them to you or send them to Brad, and then you can take it from him. But I want all of you to understand how easy it is and how simple it can be. But let's start with the chart. So I'm going to share the screen, and then I'm going to pull up the chart, and then we're going to go from there. Okay. So let's go back to the first chart here. So this is the picture of me in case you can't see me on the Zoom. And I'm a partner here at the firm. I've been a lawyer since 2003, and I was nominated for 2020 Super Lawyer, so it's kind of a nice honor. So what I want to talk about is the estate planning documents are 4 documents. So you can see in the chart here, we're talking about a trust, will, power of attorney, and healthcare directive. That's what an estate plan is. It means having these 4 documents. That's it. 1, 2, 3, 4. And we'll talk about each one and how they do it. So I want to go over, when I talk about the 4 documents, I want to talk about the last 2 because they're the easiest to understand. So we said we have to have a trust, will, power of attorney, and a healthcare directive. The chart that I have up here talks about durable power of attorney and advanced healthcare directive. These charts are documents about what happened to you. If you are alive but not well, you have COVID, you get the virus, you get hit by a truck, something bad is happening to you. You're alive but not well, you find yourself in the hospital, you find yourself unable to make medical and financial decisions. A power of attorney is a document where you name, just in case something bad happens, who's going to make financial decisions for you. Who can contact your employer, who can contact your bank, who can contact your phone company, who can contact your IRA, anything dealing with finances, file your tax return, call the IRS, call Social Security. That's what the durable power of attorney is for. It's a document that says, if you're alive but not well, so you can't see my PowerPoint? I have PowerPoint charts here, you can't see.
You're on chart number 4 on our screen.
Yeah, do you see that? Well, I have a question here from Kelly saying that she doesn't see a chart. She only sees PowerPoint.
We're only seeing the PowerPoint, and that looks like I'm on slide number 4 for you.
Yeah, okay, that's
it hasn't moved.
Yeah, I'm okay. So the power of attorney is a document that says who's going to make financial decisions for you. When I deal with a married couple, I usually name each of you for each other, and then we name backup. If your kids are old enough, you can name your children. If you're not comfortable with your children or they're not old enough, then you name other backup. You name a friend, you name another relative. But a power of attorney says if you are alive but not well, who's going to make financial decisions for you? Handle your property, handle your bank account, and handle other things that deal with money. And then the second document, which is easy, is called the Advanced Healthcare Directive. This one says if you are unable to make your own medical decision, you're in a coma, you're in surgery, you're badly injured, or for some other reason you have incapacity, then the healthcare directive is where you name who's going to make medical decisions for you. It's not automatic in California that it would be your spouse. You need a healthcare directive to write down who is going to be. You can name your spouse, you can name your same-sex partner, you can name a domestic partner, you can name your children once you're 18. So whoever it is that you want. So just think, if something bad happens to you and you get hit by a truck and you find yourself laying in the hospital bed and your eyes open, who do you want to have come in to see you? Who should grab your purse to make financial decisions? And who should talk to the doctor and make medical decisions? That's what these 2 are. When you pass away, these documents expire. They're only there for you during your lifetime. That's what this is. This is 2 documents out of 4 for estate planning. The other documents that we want to talk about is setting up what happens when you pass away. And we set up a revocable living trust. And then we also set up a pour-over will. The whole point of the trust is to avoid probate. Now, probate only comes into play, and this is hard to understand. If you have bank accounts, life insurance, retirement account, annuities, anything dealing with the bank or a financial institution like Fidelity or Vanguard or Schwab, Bank of America or Chase, if that account is owned jointly by someone, it will avoid probate when you pass because it will go to the surviving joint owner. If that account is not owned joint and is just owned by you, but you have gone to the bank or the institution and you've added a payable on death beneficiary, or a transfer on death beneficiary, and you have named people to get that money, then that account does not go through probate. It goes according to the beneficiary or the joint owner. So if you have money in the bank, you can go ahead and avoid probate by naming beneficiaries for those accounts. What you cannot do in California is name a beneficiary for your house. You cannot stick a sticky on the front door and write, if I die, my house goes to my kids in equal shares. If I die, my house goes to my favorite cousin. If I die, my house is going to trust for my young children. Your house will automatically go through probate unless you put it in a trust. Now, homes don't go into probate when they're owned jointly by two people, but it will go through probate when the second joint owner dies. So if my husband and I own a home in Long Beach, which we do, and it's titled Donald and Jennifer Sawday, husband and wife as joint tenants, then whoever dies first, it goes to the joint owner. On the death of the second, if the surviving spouse has not put it in probate, it will then go through, if the surviving spouse has not put it in a trust, then it will go through probate. So it's important for married couples, if you die together or you die shortly thereafter, to set up a family trust to avoid probate. And if the home is just owned by one person, either a widow, a widower, or a single person, to set up a trust to say what happens to that property. Now, in California, we also set up a trust to put the home, we put your rental property in there, investment property, we might put in a timeshare, and we might put in bank account, and we might also put in other money into the trust. My kids are young. My youngest daughter is 12, and my older daughter is 15. If my husband and I were to both die suddenly, we do not want my girls to get that money right away. I don't want them to get the money when they're 18 either. So I have taken everything that I have and I changed the title and the registration. So when you check title for my home, it says it's owned by the Sawday Family Trust, dated June 14th, 2004. When you look at my bank account, it's owned by the Sawday Family Trust. So if I pass away and my husband has died with me or shortly thereafter, the trust says Farmers and Merchant Trust Company shall be the trustee, because that's who I've named. And then they should take the money, take the house, and create a share for my two children. So my trust says in equal shares to my two children, we will pay for whatever they need until they reach the age of 25. So at 25, my older daughter gets her half, and then when my younger daughter turns 25, she gets her half. The trust says the trustee can pay for health, education, support, and maintenance for the girls. And once they hit 25, which is the age that I've put in, they get a check of what's left. Now, some clients have children with special needs or a mental illness, or they just say, wow, I have a son and he's not mature enough, but I think he'll be ready at 30. So then the trust is drafted based on that family. So that's kind of how that works. So if you have kids that have different needs, we can draft a special needs trust. We can draft a trust that expires at 21, 25, 30, or 35, or whatever your rules are. The trust could even say, my son is not to get the money, or my daughter is not to get the money until they graduate from college. So you can put all that stuff in the trust. So the whole point of the trust is to avoid probate and to control from the grave who's going to get what, when, and how. So we put everything in there. When we draft a trust, for most couples just have one house, especially in Long Beach, right? We're ordinary people. We work hard, we play hard, we live a good life, it's a good city, but you typically own one home. That home ought to go in the trust, and you get to describe what happened to it if something bad happened to you. So then when we draft a trust, we also draft a pour-over will. And that will does two things. It's where you can nominate guardians for minor children. So if you have young kids, you get to put in the will, something bad happens to mom and dad, who's going to have custody of the children. So you can put down favorite aunt, favorite grandma, best friends, you do whatever you want. And then we create in the will, we also say, if you're in the middle of buying property, inheriting money, something's coming in, and you die before you've put that property in the trust. So let's say you know you're going to be inheriting money from your mother, and you have another house coming someday, and you die right after your mom, and you did not have a chance to transfer that house that you just got, the pour over will would take that acquired asset and put it back in the trust. So it functions as a backup. What we want for all of you is for everything to have a beneficiary where appropriate for your bank accounts and your life insurance and financial things. And if your kids are young or they have special needs or for some reason it's not appropriate, then we make the trust the beneficiary. And then we want, if you own real estate, all of your real estate must be in a trust. Otherwise, that real property or real estate will definitely go through probate. So when we talk about estate planning, we talk about creating these 4 documents on the chart. This PowerPoint here says we talk about creating a trust, a will, a power of attorney, and a healthcare directive. Again, 3 and 4 say if you're alive but not well, who's going to make financial and medical decisions for you? You already know who that is. We just need to put it in writing to authorize them. Number 1 and number 2 talks about what happens when you're not here. That's what estate planning is. And out of my office, for most couples, it's $1,500 for me to do all this work. It's just a flat fee. Okay, so I'm gonna go look at some of these questions here. So the slides are not changing. Sorry.
Yeah, I was just noticing that we're still on the first slide that you went to.
Okay, so I'm kind of going back and forth.
It hasn't moved. So you can maybe
Okay,
check.
what can I do? You, okay, what do you want me to do?
Like you were going over the estate planning documents. We weren't seeing that slide.
Okay, all right, okay. So we have another good question here that says that if you don't have children, but you have pets, you can set up in the living trust. You can make your pet your beneficiary, and then you name a designated caretaker. So typically, by the airport, there's the plane coming over, so sorry about that. So typically in a trust, if you have pets, you carve out a pet trust. You can say all to be held in trust for all of my pets who are alive at the time when I die. So we say pet because you may have a cat or a dog. You never know. And I never want to cancel anything out that you might have more pets than you think about. So then we say you either give a cash gift, say 10,000 or 20,000 or whatever number you feel comfortable, to the designated caretaker, charity, or rescue to rehome the pet, and you put that in there. Or you can say all of the money is to remain in trust until the last of my pet passes away. And on the death of the last of my pets, then you get to specify who gets the rest of the money. So that could be a charity at that point, a rescue, or whatever you feel comfortable. So we do a lot of these, and I've done this for a lot of rescue organizations here for pet trusts. It's pretty easy. It's still a living trust because you want to avoid probate. Okay, so I'm not moving my trust around that much, but I'm going to go ahead and move along. And we're going to go to chart number 6, and it's titled Why You Should Plan Your Estate. And it's hard, but when you do it now, when you can chat me and you can be on Zoom and you can argue with me and you can say, oh, wow, this costs too much money, you're paying a normal fee. So you're not seeing any changes here?
No, the slide isn't changing. I don't know if it's scrolling on yours.
Okay. Oh, it says my connection. All right, well, maybe it is me. Okay, let me pause myself and let me see what I can do about this. I'm gonna go to a different chart.
And we will be able to send the slides later. I see that question came over, so we will be able to send a copy of all the slides at the end. But let's see if we can get them moving along as we're going through them. Hello.
Okay, so I stopped sharing, so now I'm gonna try again. So it says on my end that my share connection is encrypted. So that explains a lot. Let me try something different. Can you see this?
Yeah, that's the slide we were on, and I see your cursor moving around on it. Try
Yeah.
moving to another slide.
Can I send you the charts, Brad, and then you can start flipping?
Maybe. It's not working for you? It's not moving?
Yeah, I am flipping, but it says on here my connection's encrypted because you're recording to the cloud. So it must be my security setting. Yeah.
Yeah.
Well, let me,
Well, let me see here, because now I'm seeing the estate planning documents.
okay, can you see this? No?
I'm seeing the one that you're sharing, which is slide 3.
Yeah,
See if I can get them. Sorry for the technical difficulties, everyone. We'll work through this.
I know.
Let's see.
No, it's what's happening is it's saying that my screen is encrypted and so I'm not able to share. Because I can see the slides on my computer and I can flip around them. Okay, let me put this on hold. Let me switch gears on this. I'm gonna mute myself and mute the video and I'm gonna do
All right,
something.
one
Just
second.
give me a minute.
Send them to me if you need to.
Okay, all right.
So while Jennifer's doing that, one comment about probate. Probate is a process where everything has to go through court approval. Jennifer can explain it a lot more in detail, but especially now during our coronavirus pandemic, the courts are way backed up. So if your estate has to go through probate, it might be early next year before your case gets heard. So there's long delays. Normally it could be a few months. Now it's a lot longer than that. So that's one thing to consider as you're going through avoiding probate and getting a trust. That's a good thing to think about.
Okay, all right. I sent them to Brad by email.
Oh, you did? You send them to me or Shannon?
I sent him to Brad to show me home.
Okay.
Yeah.
Give me a second. Let me see if I can pull those up. No, not yet.
Can you share them?
I'm trying to get into.
Okay.
There we go. Bear with us. Oops. Somebody had a question, Jennifer, as we're going through this.
Okay.
What is probate exactly? And how long is it taking? I said it's taking a lot longer to go the probate process. So while I'm doing this, see if you can.
Okay, so probate is the process of transferring an asset that belongs to someone who has died, okay? So if you passed away and the asset, whether it's money in the bank or a house, is not in the trust and does not have a beneficiary, it may go through probate if it's valued more than $166,000. So, Brad, are you getting that to work? You can't pull it up? Okay.
I didn't get your email.
Okay, so let me go back and talk about my charts for a minute. My computer, when I log in for remote login, is encrypted. So I'm not able to share that. And I think that makes sense. I'm using Zoom on a different portal. So if I can't show my charts, then that's a good thing for me, a lawyer, okay? But let's talk about probate. Most people have bank accounts and they have life insurance and they have annuities. And when you set up those accounts, you name a beneficiary. So if you have 100,000, 500,000, whatever it is, you say, if I die, you put your kids on there. That money, when you pass away, the family sends in a death certificate, fills out the form, and those companies send a check, and it goes into the pocket of the beneficiary, and they go home. It's not subject to probate. If you can grab the money, you put it in your pocket, and you walk away. It's easy. That works for things that have payable on death and transfer on death features on the account. All bank accounts have it. When you open up an account at the bank, they do not ask you for your beneficiaries because they don't want you to close it. So you always have to go back to the credit union and say, if I die, where does this account go? You have to make that happen. If you do that for everything, those accounts, retirement accounts or whatever, will not go through probate. Now, you cannot put a beneficiary on your home. So if you have a home in Lakewood, Long Beach, or any part of town, your home, if it's worth more than $166,000, will go through probate if it's not in a trust. Now, tell me, Brad, can I buy a house in Long Beach for less than $166,000?
No.
Okay. So that doesn't work. So every property in LA County, except for vacant land, is going to be subject to probate because it does not have a beneficiary and it's not held by a trust. The filing fee to open probate in LA and Orange County is $465 to get it open. And then you have to run a legal notice in the newspaper, and that costs about $500. Probate has to be open for at least a year. Now, all of my probates that are currently open before the pandemic, the Orange County courts are not open. They are continuing my probate hearing for all the clients that I have now to 2021. So that means if the property has sold and the money is with the court and we're ready to do a distribution, the family is not going to see the money until next year because right now the courts are not open. If the money were in a trust, then I could tell the trustee, if you've sold the property, then you can put it out without having to go through probate. Okay, so I can see your chart. Can everyone else see them? Brad, can you?
Yes, I'm getting ready to.
Okay.
Which one do you want?
Okay, so I want you to go to chart number 7, I think. Yeah, go to chart number 7, talks about probate. Can everybody see this? Oh, good, all right, thank you, Brad, yay. Okay, so let's talk about probate. We want to avoid probate because it takes time and it costs money. Okay, so the filing fee, as you see in my chart here, says it's $465 to get probate open. Probate takes about a year from start to finish. When you open probate, you also have to run a legal notice in the newspaper in the city in which the guy died. That cost for that publication averages about $500. And then you have to post a bond because the court thinks you're going to run away with the money. That bond is based on your credit and how much the estate is valued at. So that bond cost is about $900. And then the court is going to want you to get the property appraised by the court, and you have to pay for that extra work. So if the home that is being subject to probate, you don't probate everything. You only probate what you can't grab. So if this is just a house in Lakewood, a 2-bedroom, 1 bath, and it's worth $500,000, then the appraisal cost is 1/10 of 1%. So that appraisal cost would be $500. So whatever the house is worth on the day the person died, the court will tell it. And then when you're ready to close probate, it's another $465. So you look at all these costs in a probate, it comes to about $3,000 to pay for costs, paying vendors at the window, the court, the newspaper, the bond, the appraisal. You're just paying. You pay. You're not negotiating these. You're paying these costs. That does not include what the attorneys get. The attorneys get a fee too. So whether you hire me or my competitor or any attorney in Long Beach, we get the same fee. So the attorney fee is based on the value of the property at the time the guy died. So I know it's hard to read the numbers, but if you look where it says $500,000 and it says $26,000, that means the attorney gets $13,000 and whoever is serving as the executor also gets $13,000. So what happens is when Brad signs a listing to sell that house in probate, he's having a good day, right? Because he's going to get a commission. Well, guess what? When I open up a probate and someone says, oh, so-and-so died, and we have a house worth $500,000, guess what? I'm having a good day too, because I'm going to get paid $13,000 at the end. That fee is paid to me at the end as a commission, and it's based on this formula. The attorneys get 4% of the first $100,000, we get 3% of the next $100,000, and then we get 2% thereafter up to $800,000, and if the estate is higher, then we get 1%. So this is what the attorney fees are. So in a probate, if everything has the beneficiary in terms of bank account, the retirement account, and the life insurance, it's not part of the probate. The beneficiaries put the money in their pocket and they go home. But the house is going to be subject to probate. So we have to pay all these filing costs and fees. And the court says probate must remain open for at least 4 months. So once someone passes away and we file the petition, we get a hearing date. In LA County, all of the probates are heard in downtown LA. There's no more probate in Long Beach, Norwalk, or Compton. All those courts no longer exist for probate. We only have criminal courts and civil and family courts, and there's local courthouses. All of probate is in downtown LA. So we have to be open from 4 months once the court approves it. The problem is that when you're ready to close and you've done all your work in the 4-month period, you can take more time if you need it. But if you're ready to close in 4 months and you say to the judge, I've sold the home, I put the money in the bank account, I'm ready to do a distribution, pay the attorneys and go home. That second hearing date, you have to pay another filing fee for the closing costs of $465. That hearing date has no priority. So when I closed the probate last summer for a woman who was ready to do a distribution for the money that she inherited, I got a hearing date for April 20th, 2020. I filed that last summer. So that money had been with the court. Since then, what happened on April 20th? The Orange County courts are closed, so they have continued that hearing to January 2021. So the whole point of avoiding probate is avoiding the time, the expense, and the delay. When I was younger, my mom died unexpectedly. I was 21, and she was 46 when she died. And then a couple years later, my father died. I wasn't a lawyer yet, so I didn't know enough to say, Dad, set up a trust. I had no idea. So he died when I was in law school at the age of 54, and I had to open probate and pay these attorney fees. It took a year. It was nasty. So my job to you is to tell you, oh, probate's not so bad. No, probate's good for Brad and I because we make a boatload of money, but it's not good for your family. You should be pissed off. You always want to avoid probate. This stuff is a nightmare. And the pandemic has made it worse. The courts are closed. The judge is not on the bench. There's no clerk. I can't get anything done. So when the realtors say I need certified letters or I need this from the court, I can't do anything. And most people think because the real estate agents are considered essential, that I'm essential too. Well, my court's not open. So here we are. So all of my clients that were waiting for the money this summer, all of them, I had a probate that was ready to close in May, earlier this month, for $3 million. And the brother and sister are just waiting. So we don't even have a hearing date. We have no idea what's going to happen with that money. So once everything opens up again and we can go back to court, things will start to happen, but things are getting pushed out. So when you set up a trust and you name beneficiaries, it can all be done right away. People are still issuing death certificates. The money is still coming. We can sell property. We can issue checks. It could be administered in my office, in Brad's office, in the escrow's office. It's easy. So we need to avoid probate. So let's go back to chart number 3. Okay, so I think this is the chart that would help you all. Yeah, so when we talk about estate planning documents, so we talk about trust, will, power of attorney, and healthcare directive. This is what an estate planning. And if you want to set it up for your pets, then we set it up for the pets. If you want to set it up for the kids, we set it up for the kids. If you have a best friend, we can do whatever you want. I've seen it all and I can do it all. If you don't own a home or you don't have minor children, maybe you don't need a trust, and that's okay. But at the minimum, most people in Long Beach that own a home need these 4 documents. That's it. My fee for most people is $1,500. So the value of getting that versus what I showed you in terms of probate, the big difference. Okay? So I'm going to take a short break. I'm going to look at the questions and see what else you want to talk about. Okay, so I'm going to look at the questions here. So we talked about probate, and we talked about how probate is expensive, right? So we're all getting that vibe. Okay, so then the next question is, can you add a child untitled to the home? So that's a good question. Yes, you can take your property and you can add your child untitled. You have an adult daughter and you want to say Jennifer and June, joint tenants and things like that. What will happen is if your child gets into an accident, gets into a divorce, or has some sort of judgment against her, that home is subject to the child's judgment and assets and creditors. So we don't want that, okay? We want the home to be yours. If you add your child untitled to the home, and when you pass away, yes, the child would become the 100% homeowner. When the child dies, it will go through probate. So at some point, every property needs to be in a trust for perpetuity, but that's okay. Trusts are easy to do and relatively inexpensive. Now, the biggest catch with adding your child onto a home, so let's say you bought your home in 1977 and you paid $20,000 for that home. If you add your child to that home untitled during your lifetime, and later your child passes away, when your child decides to sell the home after you pass away, the child will have to pay taxes from your basis. So if you bought the house for $20,000 and that was worth $1 million, which is not unheard of these days, that child will have to pay capital gain taxes on $950,000. If your child inherits the home, they get a step up in basis on the day that you die. So let's say you die 10 years from now, your trust says all to my child, 100%. Your child gets to step up in basis. So if the home is worth $1 million when you die, then that is your child's new basis. They get that property at $1 million. And if they turn around and decide to sell it next year for $1.1 million, then we have to pay taxes on the gain from the step-up value to the date of sale, not from when you first bought it. So putting your child untitled for a property that you've owned for a long time is usually not a good idea. It's better to set it up in a trust. If you add your child untitled, what happens if your child dies before you or dies after you? You want to plan to say, like my trust says, if I die, an equal shares to my 2 children. If I never change it, my trust also says, if one of my children don't survive me, then it goes to their kids. So I know I'll have grandkids someday, but it's built in. It's all built in there. So it's usually not a good idea, but I'm happy to help you with that. So let's look at the others. Yes, I'm doing appointments. So that's a good question. We are seeing clients in the office. We have a conference room that has a glass barrier. We can wear a mask and talk. We could do a Zoom appointment or we could do phone appointment. With all of my clients, when things are ready to be signed and after the draft has been approved, we have a meeting where you come into the office, you sit with me, and if you want to sit outside, we can sit outside. I don't care. And my notary will be there and we'll notarize and sign everything for you. And I'm in the office about 3 days a week, about 2 hours at a time, and it's working. So that's a good question. Let me look at a few more questions before I get back to the presentation. Let me see. So I have all that. Okay, so I'm gonna continue on, and then if you have more, keep chatting. So when we talk about estate planning, I want you to understand that it's this simple. It's setting up a trust, it's setting up a will, it's setting up a power of attorney and a healthcare directive. That's it. And then I'll have Brad send you all the charts. But I want to talk about, when you talk about estate planning, let's go to chart number 6. Yeah. I made this one day because I got really mad that people weren't seeing the value of what estate planning is. When you're in the hospital and I have to rush, you have to pay a rush fee. I am a lawyer. I am not a doctor. I am not comfortable around blood and medicine and all the things in the hospital. And if I were, I would have gone to medical school. So it's not fair when my clients call me or potential clients call and say, oh, so-and-so is about to die. I need you to come to the hospital, hospice, or nursing home. You're paying. My staff doesn't want to come. No one wants to come. And if it's a man that's in the hospital, they're usually embarrassed, mortified, and pissed off. It is uncomfortable. You are paying a lot of money for this estate plan. You need to do it now when you can yell at me, Jenny, your trust not working, and you can tell me, I know you have capacity. You have to do it now. You can always change it. When you're alive and well, no one's upset, and it's cheap. If you're dead, it's too late. Your family's inconsolable, and guess who's happy? Brad's happy, and I'm happy. That's the last thing you want. You don't want happy attorneys. You want us to be unhappy and do it at a normal fee. So let's go to chart number 9, and then we're gonna talk about chart number 10. So let's go to chart number 9. Okay. So let's take a deep breath. Let's talk about all the things that you have, okay? So you have a bank account, you might have a retirement account, and you might have a large life insurance policy through your work or that you've bought. We need to figure out, where does everything go? First, if it's you and your spouse, I want each of you to be beneficiaries for each other for everything. Your 401k, your retirement account, life insurance, bank account. Even if you have bank accounts in your name, so like if Brad has the bank account in his name, his first beneficiary should be Shannon. It should be like that for everything. When you set up your bank account in the beginning, you never fill out that form. Bank account, beneficiary designation. You have to go back to the credit union or Chase or Bank of America or go online and find the column that says, where are my beneficiaries? And you have to fill it in. If your beneficiaries are going to be young children, then we want to talk about naming the trust to be the beneficiary. There are certain things that you cannot assign a beneficiary to, and that includes your home, rental property, commercial property. If you have a business, a corporation, an LLC, a partnership, if you have gas, oil, mineral rights, if you have unique assets, you have a patent, you have a trademark, copyrights, royalties, all of those things ought to go in your trust to avoid probate. When you put everything in your trust is like a funnel. You put everything in it. That trust says if you pass away, we open it up and we read it. The successor trustee can take over the funnel, read your rules of the beneficiaries, and then distribute however you have put it in there. We usually do not put retirement accounts in the trust. So all of the retirement accounts that I have on here, the 401k, the 403b, your Roth, your traditional IRA, annuities, anything tied to retirement ought to have beneficiaries. So if you're married or you have children, then you name, your spouse, each of you for each other, and your kids as backups. If you have an unusual situation with a child with special needs or a child that's not going to be good with money, then you would update your beneficiaries to be each of you for each other, and then you would name the trust as the backup. So if you have a child that's not going to be able to handle an inheritance and you're naming someone else to manage it, then you have to update it that way, okay? So now when we talk about estate planning in 2020, we also have to talk about things that you might have online. You might have digital assets. You might have a lot of money in PayPal, Venmo. You might have cryptocurrency like Bitcoin, and you might have money in a gaming platform or online stores or Etsy. So if you find that you're dealing with all of your money outside of a traditional bank, then all of this stuff needs to have a place to go. It needs to be in the trust. So when we talk about chart number 10, let's go to the next chart. So this chart here talked about, let's say you have $500,000 in a bank account. You're lucky, you've got a ton of money, and you want to know, what can I do with that account? You can have that account be owned by your trust. So the bank will need to update the registration of that account to reflect your name as trustee. So let's say I have money with Vanguard. It's not retirement, it's an investment account. Then I call Vanguard, I talk to my advisor, or I log in, and I say, I want my Vanguard account to be owned by the Sawday family trust. I input all the information, so when I get the bank statement in the next quarter, on the top, it's gonna say Sawday family trust. I now know from that account owned by the trust. So let's say I still have that same account, and I want to be in control. I'm not comfortable with the trust owning it, but I want the trust to get the money when I die, like going into the funnel. Then I can have the trust become the named payable on death beneficiary for that account. Same thing. Instead of updating the owner of the account to be the trust, I'm just telling Vanguard, update the beneficiary to be the Sawday family trust as to 100%, and it will go in. That account, if it needs to be managed when I'm alive, if not well, the person who has my power of attorney can manage that account. And then let's say I have $500,000 in the bank, and I don't want it to go to my trust. I don't want my kids to get it. I want the money to go to my best friend, or maybe it's money I've inherited and should go back to my brother. So let's say on that account, I name someone else to be the beneficiary. I name my brother, Chris, to get 100% of that account. When I pass away, it's not part of the trust. My husband doesn't get the money. It doesn't go to my family. My brother can take my death certificate, take it to the bank, and he will get that money, put it in his pocket, and he will go home. What I don't want is for any of you to have any money in the bank with nowhere to go. Everything must have a place to go. And right now I can tell you, you have no idea. So you have to call. You have to look. You have to grab all the bank statements and do it between now and Labor Day and double check everything. Call. If you have Capital One, you have E-Trade, you have account. You have to make sure that you know where it goes. If you have kids and you want to avoid probate and you want someone else to manage the money for your children until they get old enough, then you have to put it in a trust. If bank accounts do not need to go in the trust, you can name beneficiary. But if you own a home, you cannot name a beneficiary for a house. The house has to come into the trust to avoid probate. It just simply has to. Now, this is California. This is what we do here. Probate's a racket. Probate's a nightmare. All of my probates that were scheduled to close from March 19th till now, none of those beneficiaries are getting their money. None. It's tied up with the court. Probate is not considered an emergency. I cannot run to the court on an emergency basis and say, oh, this family needs their money. The pandemic has happened and they're unemployed. This is not an emergency. You know why? Because the guy who died had no value for the estate planning. The court just says, too bad. You wait for us to open and we'll deal with it then. It's just simply not an emergency. It's just how it is. So now, when you don't have these documents, so let's go back to chart number 3, I think. Yeah, number 3. So let's say something bad happens and you get hit by a truck and you're laying in the hospital and you don't have a power of attorney and you don't have a healthcare director for someone to make decisions for you now. We have to go to court to get a guardianship over you. So in California, that's called a conservatorship. And I filed one recently for someone who had prostate cancer and who was in his 80s and is now showing signs of dementia. He's unable to do any of these documents because he no longer has capacity. So his girlfriend, he's not married, doesn't have children, his girlfriend wants to be able to put him in a nursing home and make decisions. So she filed for a guardianship hearing in Orange County. And we did it for her in the middle, right now. We did it in April. My hearing date for that is December 1st, 2020. How about that? My court's unopen. If you have all this stuff, it's like that seatbelt, it's like that face mask, it's like that smoke alarm. You do it all. You could do it yourself. You could hire me. You could hire my competitor, Paul. You do whatever you want. But if you have all this, you put it in a book. You put it in that bookshelf behind Brad's office. And if something bad happens, we grab it and we go. You don't put that seatbelt on because you're going to get into an accident. You put it on just in case. That's what this is. So the minute anyone's 18, they need at least the durable power of attorney and the healthcare directive. They don't need anything else. As they get older, they have more assets, they have kids, and they start to worry, and then we do all the documents. Okay, so what I want you to take away from this is estate planning. It's not that complicated. It's 4 documents. You can do them, I can do them, you can hire someone, it doesn't matter. I'm happy to help you, but I want you to understand you're doing this to keep your stuff out of court. It's not public record. You're keeping it out of court to save time and money. Okay, so if you have questions, we can talk about it, but this was really all that I had in terms of charts. I have one more chart that I can go over, is chart number 8. Let's go chart number 8. So that this one, I've done all the charts but this one. So people ask me about estate taxes. So whether or not you voted for Trump, we've got a good number, okay? The federal estate tax does not kick in unless you have more than $11 million in the bank. And if you're married, that's $23 million. So I personally don't know anybody with that kind of money. But if you have that kind of money, then we need to do some estate planning to minimize estate taxes for you, okay? If you don't have that kind of money and you don't have more than 11 million in terms of retirement account, the value of your home, and life insurance or whatever else that may come in when you pass away, if it's less than that number, there will be no tax. So that means your beneficiaries will get that money without having to pay tax. So in California, it has no estate or death tax. It could change, but it hasn't changed. Now, the federal law says that the Trump number that went into change for 11 million is set to sunset or revert back. So if you die after January 1st, 2026, and the law does not change, then the estate tax will go back to 2017 numbers to 5.49 million per person. So we do keep that in mind because we do have clients that have more than 5 million. You can own a home in a nice part of town and have done well. So if your estate is going to be higher than 5 million, you need to tell me that because we need to maybe do some estate tax planning. Most clients that I deal with just own a home. It's worth $1 million if they're lucky, and they have a couple $100,000 or more, and their estate's worth between 2 to 3 million. We do not worry about estate taxes. The government is not taking a tax. So now people ask me often, can you give money now without having to pay a tax? And the answer to that is yes. Every year, you can give $15,000 to as many people as you want, however, for that year. So you can give $15,000 to me, you can give it to Brad, you can give it to Shannon, you can give it to the lady down the street, you can give it to your daughter, you can give it to your son-in-law. You can write as many checks as you want for $15,000 as many times as you want and not report it. The minute you give $1 over, you have to report it. But that reporting doesn't trigger a tax. All that reporting does, it chips away the $11 million number. So if you give your daughter $100,000 to buy a house, you are supposed to report it on a 709 form, and your tax preparer can do that for you. And that reporting is not a gift in terms of, what do you call it, triggering a tax for the recipient or the gift giver. You just report it. And then that number for the 11 million jumps down to 11,480,000. It just goes against your lifetime gift. So that's what estate taxes are. So for most clients, we're doing estate planning to name decision makers, to control how the money is going to the beneficiary, and most importantly, to avoid probate. If you have more going on, then we can talk about more stuff. So when you work with me, I don't charge for the first meeting or the first consultation. I need to understand what you have, make sure we're a good fit, and then I quote you a flat fee. To be honest, right now, almost all of my clients right now are paying $1,500 for everything. It's a nice, happy price. I'm making money. You've got a nice product, and everyone's happy. Our firm makes a lot of money in probate. We do about 100 a year. So you can see how I can lower my estate planning prices because I'm making money on people who didn't do the planning. And then we also make money in the firm doing a lot of litigation. So I hope that gives you a good overview from how an attorney thinks and what my mind is and how simple this stuff is. So let me see if I have any more questions. Okay,
One
there's a question here saying what is an irrevocable trust?
Yeah.
So these trusts that we create here to avoid probate are revocable because we want your home to come into a trust. We want you to be in charge. And if you want to disinherit a child or sell your home, we want you to be able to change your trust or take control of everything. When people set up an irrevocable trust, you are no longer the trustee, you're no longer in charge, and you also can't change the beneficiaries or change what happens to that money. So we don't do irrevocable trust that much, but we do it sometimes. Let's say you have $20 million and you want to set aside $1 million. You could put it in an irrevocable trust for your daughter or for your son. But for most people, we don't want that. Now, when we set up a revocable living trust and you pass away, that trust, the moment that you die, becomes irrevocable. But during your lifetime, I want you to change how you're going to manage your property. I want you to change your beneficiaries. I want you to change your successor trustees. I want you to be able to fix all that. If the trust is irrevocable, you can't change anything. And I don't know anybody, we don't do it that much. We maybe do it once or twice a year, but that client has to be super wealthy and be willing to part with the money and no longer be the trustee or have control. That was an interesting question. So anything else, or do you want me to repeat or go over?
Don't see any other questions.
Okay. All right. So sorry about the glitch. I wish I would have known. Next time I'm just going to have my...
Okay, we got
I know.
we got the slides going, so that's good. And I will, for everybody who attended, I will share these slides so you can go back and look at them again. That's okay, right, Jennifer? Yeah. And there's Jennifer's email. If you have further questions or want to set up an appointment, strongly recommend it. Every couple of times a year, Shannon and I get calls. Hey, I need to establish the value of my property back when. And it's always as a result of somebody asking a probate question. And
coming. I mean, I know it's difficult. I appreciate your patience. But if you have questions or you want to argue with me, send me an email. I'm happy to tell you what I think. And if you want a consultation, just let me know.
Okay.
Okay.
So that is it. If there's no other questions, we are done. So thank you for joining us, the people that did sign in, and glad you were able to come in, and we'll talk to you soon. Thanks, Jennifer.
Okay. All right. Thank you. See you guys later.
Bye, everyone.
Okay.